wait for them. You are now joining the meeting.
Hello, this is Judge Lynn, who just joined the line.
I am the accused.
Is that Mr. Quintero?
I'm the accused, allegedly, David Quintero.
All right. Well, welcome. We're going to go ahead and go on the record. We are here in SP 2017-024. 2017-0042. This concerns the state of Arizona as well as David Quintero and Kimberly Hadley. Both Mr. Quintero and Ms. Hadley are present representing themselves. The state of Arizona is represented by the Attorney General's office with Assistant Attorney General Amanda Ehret present. And let's have, Ms. Ehret, how would you like to begin today? Would you like to put someone on the witness stand?
I would like to ask Mr. Quintero some questions, see if that's possible.
All right. Mr. Quintero, if you're able to stand and raise your right hand, I'd like to have you sworn in.
No, I'm not interested in that. And for the record, I reserve all my rights and waive none. I am present by special appearance, in propria persona, as the accused. There are multiple permanent due process errors and violations on the record. This matter is tainted. These errors cannot be cured. This matter is over. There's only two options. You dismiss this matter with prejudice, or write an order so that I can appeal and file my lawsuits. There's nothing more for today.
Well, sir, I disagree with that. We are proceeding. You have the option of affirming rather than swearing. Would you prefer that?
I appreciate your question, but I'm not interested.
So the problem if you don't swear or affirm is that nothing that you state will be sworn testimony. Let me just ask one more time. Do you wish to be sworn in or affirm, or are you refusing to do that?
I appreciate your question, but I'm not interested.
I'll consider that to be a refusal to be sworn in or to affirm. In light of that, Ms. Ehret, do you still want to question Mr. Quintero?
I do not, Judge. I can simply provide an update and some recommendations.
All right, very good.
So since the last hearing, there has been absolutely no information received by the Attorney General from Mr. Quintero. Until about May 23rd, payments were coming in weekly through unemployment benefits. I don't know if Mr. Quintero is still receiving those unemployment benefits. As I stated, the last payment was May 23rd. I do want to note that this is Ms. Hadley's enforcement action. I know at the last hearing there was some statement by Ms. Hadley stating that she did not find review hearings to be helpful, and given Mr. Quintero's complete lack of compliance, I'm not sure how helpful continued review hearings will continue to be. Nevertheless, as I stated, payments are coming in, or were coming in by unemployment. At this time, the state will not be requesting review hearing, and I believe Mr. Quintero is still found to be contempt given the fact that he has not complied with any court orders.
Based on your records, are all the payments coming in as involuntary administrative payments from the unemployment or pandemic unemployment, whichever it might be?
Yes, Judge. Everything has been involuntary.
All right. I was wondering, based on my review thus far, whether it was going to make sense to have continued review hearings. Ms. Hadley, I'm not asking to be sworn in unless you would like to be at this time. But what were you requesting that the court do today?
I don't know. I do want them to keep enforcing because I have to keep providing for our daughter. Obviously, I have since she was born, and Mr. Quintero has always made it clear that he has no intention of supporting, but has nonetheless been so harassing to me that I think it's only appropriate that we keep reminding him that financial responsibility is two parents, not one. So I don't know what the court wants to do in this matter because he won't be content everything, obviously, you can see. So I don't know what we do. Last time I told the court, it was just inconveniencing me because Mr. Quintero he has no desire for taking any of this, obviously.
All right.
So I'm not sure what the appropriate measures are to do,
Well, if we don't continue to have review hearings, that doesn't mean the enforcement stops. You are working with the 4D agency, and so the regular administrative remedies for collection continue to be in place. All right. And you have been receiving regular payments now since for a period of months now, is that correct?
I have been receiving whatever they intercept, like a percentage of whatever they intercept. So yeah.
All right.
Which I'm sure when that stops, it will stop because I don't think he has any intention of paying his. So.
Well, regardless, at the moment you are getting payments, even though those weren't, as far as we know, voluntary, correct?
Correct. Yeah, he's never made a voluntary payment.
All right.
And I'm getting a percentage, yes.
Okay. Mr. Quintero, there may be some outstanding documents that you had attempted to file previously. I'm doing a review, and I will address those in writing. But for today's purposes, the court will find that it has jurisdiction over the parties and subject matter. That finding is understood to be over the objection of Mr. Quintero. The court finds that payments are coming in regularly through administrative collection remedies, although not voluntarily. The court does not see any benefit at the moment to continuing to have review hearings, and therefore will not set a review hearing at this time. However, an additional hearing could be requested in the future should that be necessary, or if payments stop. The court affirms the prior child support order for current support in the amount of $317 per month, and orders Mr. Quintero to make such payments as well as anything additional that he is able to make towards the outstanding arrearages. The court will sign this minute entry. Mr. Quintero, one thing I noticed as I was reviewing some documents is it looks as if you have not complied with Judge Furland's prior order that on anything that you are attempting to file, you note that you have been found to be a vexatious litigant. The reason that's important is because it affects how it's routed, and if it's not clearly labeled, it may not get to me as quickly for review. All right, I believe that's all we can do today. Is there anything else that you are requesting, Ms. Erin?
No, Judge, thank you.
All right. Folks, I'm going to let you go about your business. What, sir? I think that was you. Okay, we'll go ahead and adjourn the hearing. Thank you.
Thank you.
Bye-bye.